judge presiding. All persons having business with this court are on your good attention, you shall be heard. God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Well, good morning and welcome to a session of the 5th District Court of Appeal. I have the privilege of presiding this morning, and to my left is Judge Jacobus, to my right, Judge Sawai. I'm sure you all know them already. As usual, our criminal cases will have 15 minutes per side. Our civil cases will have 20 minutes per side. If the appellee or if the appellant wishes to reserve some time for rebuttal, please let me know. I'll put it on the clock, and I'll also try to give you a hand signal that you're about to run out of time. If you have any electronic devices, please turn them to the off position, as they may interfere with the driving of this court. So, okay, that was a joke.
With a what?
All right, so let's proceed with the first case, Hawthorne versus State.
Your Honors, my name is Chan Muller. I'm a lawyer from Winter Park. I represent the appellant, John Hawthorne. Judge Monaco, if I could have you warn me, I'd like 3 minutes of rebuttal.
Sure.
And if you could give me a 2-minute warning when at about 10 minutes.
What?
Well, I hope my argument's clear.
Oh.
At 10 minutes, if you give me a 2-minute warning, because I want 3 minutes of rebuttal, and I'm
I see.
that's what.
Yeah.
Okay?
Yeah, well, that may work out. We'll see.
Okay. In this case, the trial court committed error in not granting a judgment of acquittal at the end of the state's case with regard to the issue of whether or not Mr. Hawthorne was guilty of second-degree murder, i.e. that the homicide was from a depraved mind evincing an evil intent or hatred as opposed to manslaughter.
So what's the difference between the two?
Your Honor, the difference between the two actually is a factual distinction, and the facts in this case are consistent with a host of Florida cases where courts have reversed trial judges who refused to grant the judgment of acquittal, because in this particular case, the state's key witness, Cameron Miller, testified it was his idea to go to the camp to see this unusual man who Mr. Hawthorne said had been trespassing on the property. And the difference between the evil hatred versus culpable negligence can best be shown in the Light case, which even the state acknowledges is applicable here, because if the facts show that Mr. Hawthorne was reckless or even overly reckless in his apprehension of whether or not he was in imminent danger of suffering great bodily harm, as a matter of law, the case should have been granted on a judgment of acquittal. Here we have the key witness for the state, and it's interesting, at page 3 of the state's brief, a big point is made of the fact that Mr. Hawthorne basically was an officious intermeddler because his father, Claude Hawthorne, did not own the property anymore. But the record clearly shows that Charles Hawthorne, who is a co-owner of the property and a member of the family...
What difference does it make who owned the property?
Well, Your Honor, that's one of the facts. I mean, obviously, you could commit second-degree murder on your own property, but the state...
Well, and what did you mean by that the victim was an unusual man? What difference does that make?
Well, the state argued that this was evidence of depravity on the part of my client because they made a big case in the brief that my client had some sort of hatred toward homosexuals, and that the focus was on the fact that the decedent was a homosexual. And Mr. Milner testified that he never heard my client ever say one word against Mr. Boner. Mr. Milner had been living with John Hawthorne and his family since April. This occurred in July. He not only...
The facts and circumstances reveal that your client cut the tent.
Correct.
While the person was in there. The person got up, walked away, and then your client pursued him. And stabbed him, what, 8 times?
No, sir, 12 times.
Was it 12 times?
Yes, sir, but here's the main...
And you're saying that, he was just doing that basically out of self-defense and self-preservation?
Well, Your Honor, I think we got to break this down, if you don't mind. Number one, he had what was called a common pocket knife by one of the Ocoee officers. It was a 2-inch blade. The undisputed facts were that when they came to the camp, yes, Mr. Hawthorne did
one of the doctors, I think the doctor testified, did the autopsy, one of the wounds was 4 inches deep.
Well, it was 4.5 inches.
4.5 inches.
And Your Honor, that supports
If we're being that precise, the blade was 2 7/8 inches long.
The knife was 2 7/8. In Judge Sawaya, I think that's an important fact because all 3 medical examiners, Dr. Henson, who was the state's examiner, Dr. Anderson, who was a retained medical examiner, former medical examiner in Orlando, and Dr. Cyril Wecht all testified that the 4.5-inch penetration was consistent with what Milner said. That is that Boner, who was 6 feet 1 inches tall, outweighed my client by 40 pounds, was straddling my client, and Milner said that he didn't see who started the fight. Hawthorne's testimony was unrefuted that it was Boner that jumped him. But to get to your question about the penetration, the unrefuted evidence was that when Mr. Milner pushed Mr. Boner to get him off of Hawthorne because Milner thought that Hawthorne was going to be seriously injured or killed by Mr. Boner, the push occurred, and that caused the one fatal wound. The other wounds, there were 10 superficial wounds on his left arm and 1 posterior wound that did not penetrate the chest cavity on the left side. All 3 doctors testified.
Well, the testimony was there were 8 stab wounds and 3 incised wounds.
Well, but the key fact here, Judge, is only 1 wound was fatal, and that was the wound that we maintain and all the medical examiners say was consistent with Mr. Milner pushing Boner onto Hawthorne. And what happened, it was...
And the jury heard all this evidence and testimony, didn't they?
They did. The judge, Your Honor, in these cases that have been reversed, the judge here, it was legally insufficient to get to the jury because in this particular case, the state never refuted the legally sufficient competent evidence that was raised by the defense. And what happened here is that there was an internal bleed on Mr. Boner. He walked a quarter of a mile after the injury occurred. There's no way that either one of these boys could have seen.
Was there evidence that the victim asked them for help and they turned around, walked away, and just left?
No. The evidence was that the victim said that he would like to be taken to the hospital and that the boys felt, in fact, Milner said it looked like while he was bleeding it was superficial and he had nothing more than a nosebleed.
They left him there and went and he died.
Well, what happened, he left and he walked to the 7-Eleven. And, Your Honor, there's no way that either one of these young men could have determined that Mr. Boner had a wound that was going to kill him.
Well, I mean, here's the victim that stabbed, you said 11 times or 13 times?
12.
And the victim asked them to take him to a hospital and they just turn around and walk away? And
Your Honor...
supposed to...
Well, Mr. Milner didn't help your client too much, did he? I mean, and their testimony was not the same. Your client had a different version than Mr. Milner did.
Well, but Mr. Milner's testimony was consistent with our client's testimony, Your Honor. First of all, Milner's...
Some parts, but not all.
Well, the key parts are that he never saw, in this so-called re-engagement that the state talks about, all Milner said is he saw some punching and pushing. There was no evidence of any stabbing, and also the state relies very heavily on the so-called re-engagement to show the evil intent, but that's inconsistent with the physical evidence because the medical examiner said the only thing that killed him was the wound that could have been caused by the pushing. Judge, can I just address one thing, because I think that's respectfully a red herring about not going to the hospital. In the Real case, which we have cited, and I think is a critical case in this particular...
Well, you're the one that's talking about evil intent. I mean, you brought up evil intent and that.
Well, I did.
And that sort of thing. And so
I
why wouldn't
did.
that question be relevant to that?
Well, because the state's made a big deal out of the fact that the defendant did not drive the decedent to the hospital. And the reason that's important is because in the Real case, which I have cited here, there was a man that had been a 17-year correctional officer who had training in medical assistance, and when the police came, after he had shot a victim twice, he was standing like this over the body of the victim, and the state argued that that was evidence of a depraved mind because he didn't help the guy because he had medical training. My client didn't have medical training. My client didn't shoot somebody twice. This was an 18-year-old kid and a...
Well, there was evidence that he just stabbed him 11 or 13 times. I mean, that...
Well, the reason he was stabbing him 12 times, Your Honor...
12 times, okay, well, whatever the number is.
...is because he was pinned down, and the examiner said that the decedent had abrasions on his knees, the decedent, which was consistent with the 6 foot 1 inch man that weighed 40 pounds more than my client, pinning him down, pummeling him relentlessly, to the extent that Milner came over and kicked the guy, pushed him, and that's why the blade...
Well, the evidence was inconsistent there. I think some of the evidence was that he pushed him off. Some of the evidence was that he pushed him down.
Well, what we do know is that he had to get this fella off my smaller client, and my client managed to get the weapon out in order to try to poke him and get him off, and all those wounds were consistent with that.
Is Milner the one that testified to the jury that your client, called the victim faggot, and he was going to whip his ass?
Yes.
And then your client said, "No, I never said anything."
That's true, but in Judge...
It shows some kind of evil intent, if you will.
Well, here's the thing, Judge. He said he was going to whoop his ass.
Yeah.
And he said, you kind of look like a faggot because you got red pants and a yellow shirt on, and you use sunscreen. That was in the same conversation where my client said, "By the way, do you smoke marijuana?" This is inconsistent with some sort of evil intent. And Milner, I think a more poignant question would be, what kind of plan was there? Had my guy talked about the fact that he was going to hurt this man or kill him? No. On that particular day, it was Milner that said, "I just want to go there and look at the campsite." Nothing was ever said.
When was this?
It was 6 in the morning.
6 in the morning.
These guys had been up drinking
all night?
All night, starting on July the 21st. These are two young guys who were riding around on an ATV. The Hawthorne family had numerous trespassers out there. And is this morally right? Is it something that you'd want your son to do? No. But what we're dealing with here is an issue of what was going through Mr. Hawthorne's mind and whether or not he was using justifiable force. Another thing, if you recall...
It seems to me, the jury heard all that. There was enough there, to overcome a directed verdict, it would seem to me, based on all the testimony.
Well, Your Honor, that's why we got the gatekeeper with the judge. It's like in the Brown case where the circuit judge in Osceola County denied a motion.
Yeah, but the gatekeeper can't ignore the rule that you have to consider the evidence in light most favorable to the state either.
That's
and
true.
I don't see how he could have granted a motion for directed verdict based on this evidence, when you consider that standard.
Well, Your Honor, if you look at the case law, if you look at the 5th District Court of Appeal cases that have done that, it's consistent with what we have here, because the case law supports the fact that if the defendant, even if the defendant acted recklessly, even if the defendant used bad judgment, as a matter of law, there can be legally insufficient evidence that would support going to the jury. And we also respectfully submit that there was never any refutation on the question of self-defense. I think I got 2.5 minutes for rebuttal.
Yeah, 2 minutes and 11 seconds, since we're being so precise.
Yes, sir.
To be precise. 2 7/8.
May it please the Court. I'm Rebecca Wall, Assistant Attorney General. I represent the state in this appeal. Both of these issues presented challenged the trial court's order denying the motions for judgment of acquittal, and clearly, as Judge Sawaya has pointed out, the standard is whether or not the state presented competent substantial evidence from which the jury could find the defendant guilty as charged. And the state, of course, argues that it did. I just would point out...
So what's the evidence of mens rea?
Pardon me?
What's the evidence of mens rea?
The evidence of mens rea, and if the case law identifies that depraved mind is characterized by acts or a series of acts that tend to show that the defendant acted with ill will, hatred, malice, evil intent. And I think the state showed from the minute they arrived at the campsite till the time they left, the series of events, series of acts, showed that the defendant had ill will.
Tell me what they are.
Starting with his approaching the tent, cutting the tent. At 6 o'clock in the morning, there's a tent. He knew that the tent this was a campsite that was occupied. He had seen it occupied.
He claimed he cut it open to see if there was anybody there, right?
Perhaps. Of course, a tent would have a door. Did he cut it open to see if there was someone?
Or did he was afraid to go through the door, wasn't he, or something?
His testimony was that.
Right.
Regardless of why he cut the tent.
Right.
When the victim emerged, he began telling him, you got to leave, you got to leave. And he decided to help the victim leave by cutting the clothesline where all the victim's clean clothes were hanging, called him names, told him he was going to whip his ass, showed him the knife. When the victim decided that and I think there was testimony that the victim tried to, talk to him. I think the defendant even said he kept trying to talk to me. I would argue that he was trying to calm the situation. When he finally decided that the best thing to do was to leave, he began leaving. He was leaving. He was going in the direction of the convenience store. And Mr. Milner's testimony was that the victim had walked completely past the defendant, leaving the property. The next thing Milner sees is, and it's not clear how he, didn't notice how the interaction occurred, but the next thing he sees is that they're on the ground tussling. There was no testimony that the victim ever hit the defendant. In fact, the medical testimony was that the wounds on the victim were defensive wounds and did not indicate that he had hit the defendant.
What sort of injuries did the defendant have?
The defendant, the best I could determine from the evidence was he had a mark on his face somewhere, a red mark. I think it was characterized as a red mark. Now, in his testimony, he testified that he had been hit in the mouth, but my recollection is that there was not evidence of that other than his testimony of that. And I think he said he had been hit on the top of the head. Other than his statement to that effect, I don't recall that there was any evidence to support that, and that was in his testimony, not in his statement to the police post-arrest. From the time the tussle began to occur, according to Mr. Milner, there was no evidence ever that the victim ever had any kind of a weapon or anything to inflict any kind of injury or harm to the defendant. Milner's testimony was that he pushed the victim sideways, and that was clear. He testified it was sideways. He pushed him off, and then the defendant's statement to the police actually supported that. It was not until the defendant testified on the stand that he changed his story to indicate that Mr. Milner had pushed the victim onto the knife. And in fact, I think the evidence shows that the fatal stab clearly occurred after Mr. Milner had interceded, because the defendant asked Mr. Milner if he had cut him, if he had stuck him, and he knew there was blood on his knife. So the fatal stab occurred according to Mr. Milner's testimony, after they two were getting to their feet, and there was a throwing of fists, a further engagement. The defendant himself admitted that he stabbed at the victim at least 2 more times after they had gotten to their feet. Further series of acts show that afterwards the defendant knew he had stabbed the victim because he showed the blood to Milner. There was blood on his clothes. He went home, showered, and washed his clothes, so we knew that he recognized he had injured the victim substantially enough to have gotten blood all over himself. And then, of course, part of the series of events, of the actions, was the victim's plea to the defendant to take him somewhere where he could get some medical help. And, of course, the defendant's response, get the F off of here, get away from me, and he pushed him away, and they drove off. So it's a matter of, in this particular case, the mens rea, at the very least, was ill will, and it's shown by the whole series of acts before, during, and after the stabbing. Clearly, it was sufficient evidence from which the jury could find that the defendant acted with a depraved mind. Now, as to the self-defense, excuse me, absolutely, it's clear that once the defendant makes a prima facie showing of self-defense, the state has the burden to rebut that. The self-defense is, under the statute, is a person is justified in the use of deadly force only if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, to prevent imminent commission of a forcible felony. And I would argue that it's not clear at all that the defendant even made a prima facie showing of self-defense. There was no weapon on the victim. There was no testimony that other than the defendant's self-serving testimony on his own behalf, that the victim ever even struck the defendant. And even if that was the case, to pull out a knife, inflict 12 wounds, ultimately inflicting a 4-inch wound with a 2 7/8 inch blade, is certainly bringing a way more force to a situation that it isn't even clear who started it. I would argue that the defendant didn't even make the prima facie showing of self-defense. But even if he did, clearly the state rebutted that by showing that, according to Mr. Milner's testimony, there was no indication that there was, and in the defendant's own testimony, he knew he wasn't in imminent danger of death or great bodily harm. He recognized in his statement that the victim was a goof, he wasn't going to hurt him, he just didn't like those kind of people touching him and being on him. And so I think it's clear that the state rebutted the defense of self-defense, and it's also clear that the state presented substantial, competent evidence from which the jury could find the defendant guilty as charged, both as to the mens rea and to the self-defense. The state then asked the court to affirm the judgment and sentence.
Thank you, counsel.
Your Honor, in the trial testimony, the question was asked about the type of injuries that Mr. Hawthorne suffered, and there was testimony from the medical examiners. I think Dr. Anderson testified that he had looked at the photographs taken of Mr. Hawthorne, and the face showed that there was the bruising, which is consistent with what Mr. Hawthorne's testimony was. Also, the testimony from the medical examiners totally refutes the state's theory with regard to the depraved stabbing, because all three of the doctors said that had this been a stabbing, which the state asserts from a standing position, a depraved stabbing in the chest cavity, there would have been tearing around the wound, there would have been the beginning of bruising, and because those factors were not present, it is consistent with the fact that the injury occurred, sadly, accidentally, when Mr. Milner was coming over to get Mr. Boner off of Mr. Hawthorne. There was no testimony ever by Mr. Milner that a knife was used in the so-called re-engagement. Of course, Hawthorne denied the re-engagement, but the testimony at best for the state was that there was some pushing and shoving. So I think it's clear.
Counsel, before you run out of time, let me ask you one quick question.
Right.
What do you think we ought to do with this case?
Well, Your Honor, I think that as a matter of justice, the court should reverse and remand for resentencing under manslaughter at worst. We argue that there was a legally sufficient basis for self-defense. We argue that very strenuously, and the cases that I've cited, including cases out of this district court, support that, because the state's own witnesses don't have legally sufficient evidence to support the denial of a judgment of acquittal. So it's certainly not second-degree murder.
Your time is up.
Thank
Thank
you.
you very much. All right.